As you heard, we will have a look at two remaining countries from our list, and we will try to cast light on the environment in which town law books were created and produced. First, uh, first it is Austria that will catch our attention. Starting with the origins of medieval towns in a legal sense of term, we can say that their gradual development in today's Austria reaches back to the 12th century. Just 1 century later, according to the estimation, there seemed to be about 70 agglomerations with urban qualities in the Austrian lands. At the same time, fortifications were already seen as a specific architecture and historical feature distinguishing towns from market villages. The majority of Austrian towns were small settlements without imperial immediacy. It was typical that throughout the Middle Ages, such places didn't exceed an area of 15 hectares, and their population remained well below 1,000 inhabitants. Therefore, Vienna, as one of the European centers with a population of 20,000 around the year 1500, was an exception. Yet, there was another legal difference between urban areas. Some towns were subordinated to the landlord directly. These were the so-called Landesfürstliche Städte, others indirectly by being owned by secular or ecclesiastical nobility, recognizing the supreme authority of the ruler. These were so-called patrimoniale Städte. Precise data are displayed on the slide in front of you. As far as the administration of Austrian towns is concerned, it resembled other countries in combining manorial and self-governing elements. The situation in royal towns, including the most significant and well-researched Vienna, was the following. On the one hand, town lords were used to appointing a magistrate, the so-called Stadtrichter, who acted on their behalf and was responsible for carrying out municipal government and judiciary. On the other hand, burghers tended to hold meetings in the form of a general assembly to defend collective interests and decide on their affairs. In addition, there was a smaller self-governing committee consisting of prominent townsmen, which over time became a stable institution known as a town council, Stadtrat. This allied group of citizens met together at a town hall, perceived as a sign of municipal autonomy. Their regular sessions were chaired by the Bürgermeister or Bürgermeister, if you will, as the leading representative of a local community. He was elected by burghers and subsequently approved by the lord. In contrast to larger towns, in lesser ones, such a council was usually presided over by the magistrate, whose official career depended instead on the will of the town lord. Adding the historical perspective and moving from the Middle Ages to early modern times, we can observe two main tendencies in the development of towns. First, there were fewer periodical changes of personnel, and some areas even recognized the principle of inheritance. As a result, municipal governments turned into rigid bodies controlled by a small circle of influential men. Secondly, the autonomy of towns was more and more limited, which culminated in the Enlightenment reforms of Joseph II, who finally replaced corporative authorities with a bureaucratic council. At this point, it is time to shift our focus to legal regulation. Historians assume that by the end of the 15th century, most Austrian towns had and used a written compilation of municipal law. Some of these centers inspired other, less developed localities, thanks to an advanced legal culture. As a result of their influence, families of municipal law came into being, such as the well-known circle established around Vienna. Although the Vienna Council, as the supreme tribunal within the family, was deciding only in the most severe cases, its legal opinions and provisions gravely affected the lives of both inhabitants and foreigners. After receiving Vienna law, townsmen from the outside world adapted its wording to their own conditions and needs. There is evidence that some urban communities were merely inspired by Vienna law, whereas others embraced it fully. Hans Planitz argues that Vienna didn't have any mother city. However, there can be no doubt that its privileges drew on similar foundations as privileges granted to other towns in Europe. Generally, we can say that municipal sources preserved in Austria from the Middle Ages contain above all economic and criminal law rules. Despite the vast prevalence of domestic law, Roman law influences were also present to a small extent, especially in inheritance law, mortgage law, and litigation. At the end of this section, we shall eventually discuss legal sources and their producer. In the early 13th century, charters were still a rare phenomenon in towns. If the need arose to record some legally relevant facts, burghers turned to scribes employed by landlords or church institutions, which traditionally supported written culture. Therefore, it is not surprising that the oldest municipal document on legal activities of a town was found in the archives of the Benedictine monastery Michalboyan. It was not until the 13th century when profound changes happened, in the course of which first codifications of municipal rights appeared. The overall need to introduce written production and to define more precisely the role of local self-government increased after 1276 with the arrival of the Habsburgs, who brought a refined style of administration from Swabia to the Austrian lands. Municipal scribes, so-called Stadtschreiber, in modern times also called syndics, are first mentioned in the sources from the 13th century. The majority of medieval cities seemed to lack any permanent office of a scribe. Meanwhile, chanceries with a larger staff and more subtle organization were established in several urban centers during the reign of Rudolf IV in the second half of the 14th century. General requirements for clerical work included marital origin, physical condition, good reputation, and professional training. As part of their versatile job, scribes were also involved in carrying out the municipal administration and judiciary. In addition to preparing and archiving documents, they were responsible for handling town books. In Austrian towns, the use of manuscript records intended for official purposes dates back to the 14th century. One of the oldest and most precious examples comes from Vienna. We are referring to the so-called Eisenbuch, which is named after the decorative iron fittings on the cover and could be created around 1320. While at the end of the 15th century, town books were often of mixed content, from the 16th century they were gradually being replaced by documents with a specific orientation. At that time, proceedings from council meetings started to play a major role and were therefore recorded separately in the so-called Ratsprotokollbücher. Here on the slide you can see Eisenbuch with its famous iron cover. This was the last slide concerned with Austria, and now we are shifting to Poland. As we have seen, it is no exception in the European context that the first urban settlements were established in Poland in the 13th century with the contribution of colonists from the West. These foreign settlers were coming as part of the so-called German colonization and brought legal innovations in the form of unwritten customs. Their new locations had to adapt to the prevailing conditions at the place of establishment. However, a so-called constitution of newly located towns generally didn't differ so much. Thus, the same concept of administration spread everywhere, with a simple or more complex structure depending on circumstances. That is something that remained unchanged until the division of Poland in the 18th century. Among owners, we can count either the ruler himself or other landlords, which means that Polish towns were divided into princely or royal, so-called miasta książęce, królewskie, and private, miasta prywatne. For the sake of clarity, it is essential to remind that in the literature we can sometimes come across the classification of towns according to their size and economic potential based on text sources of that time. As a result, there are four categories of urban centers in Poland to be distinguished: the largest, medium, smaller, and the smallest. Historians believe that there were almost 700 towns in Poland around 1500, and that more than a half belonged to the last category. Although the percentage of the smallest towns decreased over time, it is obvious that until the late modern era, the Polish urban landscape was filled with petite towns. Again, there are more accurate numbers listed on the slide in front of you. Moving to administration and judiciary, it is hard to overlook that from the 13th century onwards, the most crucial post in towns was held by a man who represented the landlord and was called vogt, voit, or šūtais, sołtys. Not only did he take care of internal affairs, but he also acted on behalf of the town with outsiders. However, his former superior position soon weakened due to the rise of the communal movement, which turned cities into self-governing corporations. Such a profound change was initiated already in the 13th century by burghers who were uniting to defend their interests. They were forming larger assemblies, so-called pospólstwa, overseeing municipal finances and participating in critical decisions in local policy. Besides, they created small councils, so-called rady miejskie, consisting mainly of the wealthiest burghers, which gradually took over the town and manorial positions in the city government. Any degree of self-government depended not only on the size of a town, but was also affected by its economic and social status. In more developed centers, the acting council and the council of aldermen were in charge in the 14th century, both councils usually consisting of 12 members and, on some occasions, forming the large council. As for the council's management and the holding of meetings, these tasks were entrusted to one or more burgomasters, burmistry. While in towns established under Libeck law, councillors also participated in the judiciary. A special judicial authority was constituted in towns that received Magdeburg Law. It was called the Bench of Lay Judges and usually consisted of 7 members. This was the so-called Lava Sondova. Trials before them were always presided by the magistrate, appointed either by the landlord or the council. Full attendance of sworn men who participated in the decision-making was not necessary for the tribunal to conclude a case. Regarding the matter and the position of parties, ordinary and extraordinary cards were distinguished. The former took place at fixed dates, and burghers could turn to them in disputed and undisputed matters. The latter were convened as needed and provided legal protection to foreigners or citizens who sought to avoid any damage or delay. Another question to think about it is which rules were relevant for judicial decisions. Most urban settlements in Poland received Magdeburg Law and its daughter laws such as Chełmno Law and Środa Law right after they had been founded. Chełmno Law spread widely over eastern Pomerania and Mazovia. Środa Law became common in Greater Poland. On the other hand, only a fraction of towns obtained Liebek law, which ruled in some towns in the historical territory of Prussia. Because of its origin, municipal law in Poland was generally referred to as German, jus teutonicum. However, in the process of legal transfer, it did not remain the same body of law. Sources went through a complex adaptation. Following the needs of recipients, the use of Magdeburg Law was facilitated by its additions and translations to Latin and Polish. In comparison to the legal circle of Lübeck, unified to a larger extent, Magdeburg Law was strongly differentiated in Poland. Along with the rights and regulations of Magdeburg Law, other related sources of the so-called German law, such as the Saxon Mirror or the Meissen Law Book, made their way to the east. The authority of Magdeburg Law was based on the privileges obtained from the lord of the town and on legal regulations provided by higher municipal courts. Daughter towns were turning to their mothers with complicated legal issues, the solution of which subsequently led to written fixation and stabilization of the customary law. From the 16th century onwards, knowledge of Magdeburg Law deepened further as a result of its scientific elaboration by trained jurists. Thus, local regulations based on this law remained in force until the end of independent Poland in the 18th century, when it was replaced by Enlightenment codifications and reforms. The history of town offices and legislation they produced, which also needs to be addressed, if only shortly, is closely related to the cultural level of urban society. Since literacy ceased to be a monopoly of the clergy in the second half of the 13th century, written communication penetrated both the public and private life of townspeople. As the knowledge of writing and reading increased, important laws began to be issued in a different manner. At first, they were announced and read at gatherings of residents at town halls and churches, while from the second half of the 15th century, posting written copies either at town halls or on church doors proved to be more effective. Contrary to older opinions, it is now generally held that with a few exceptions, for example Wrocław, chanceries equipped with professionals of writing didn't emerge right after self-government authorities had been formed. Because of the lack of evidence, it is somewhat assumed that initially clerics were hired ad hoc, or small scriptoriums with a minimal workload were active in most areas where the council was ready to finance them. It is also significant that in the beginning, clergymen prevailed among scribes. According to the latest views, chanceries became pillars of the city administration from the 14th century, when the urban economy grew hand in hand with the consolidation of self-government. Activities of scribes in Polish towns are first documented in Kalisz and Kraków in the latest decades of the 13th century. In contrast to smaller towns, in bigger ones, clerical work expanded, so permanent scribes were hired, their numbers rose, and their jobs started to be more specialized. At the same time, there was a trend of unification of forms and methods of clerical work. Scribes generally held their posts for life, however, in some places these men had to apply for the renewal of their job repeatedly. They were expected to meet a set of requirements such as language competencies, familiarity with the legislation, mastery of clerical art, knowledge of arithmetic, and the ability to keep a secret. The high intellectual level of at least some members of the town chancery reflects in the preserved sources, which also include compilations of municipal rights and regulations. In a variety of documents, produced in town offices, charters belong to the earliest ones. At first, only documents addressed to towns were kept in the archives. It was not until the turn of the 13th and 14th centuries when municipalities began to issue copies and extract of documents for other recipients. In Poland, scribes not only produced charters, but from the end of the 13th century also kept official books. Those with specific content were produced in larger and medium-sized towns and often remained in use until the modern era. On the contrary, the frequency of records in small towns was lower, so mixed manuscripts were sufficient here. Following the typology of Janusz Tandecki, we can distinguish town books in Poland in the following categories. First, general council books. Second category, administrative financial books. And the third, court books. In addition to them, there were other juristic documents collected in town chanceries, for example, manuals of officials in which legal norms, court regulations, and privileges were recorded, or there were also statutes of town councils, so-called wilkierze. A famous Polish edition of Magdeburg Law is Jus Municipale by Pavel Szczerbich of Lwów, the picture of which concludes our presentation. Thank you for your attention.